My name is Nur Solihah binti Abdul Karim, and I will talk about the case introduction. So first one is the main issue. A dispute over festival aid bonus payment given to bank employee. NUBE attempt to summon Human Resources Minister Stevenson as a witness in the case. Number 2 about parties involved. National Union of Bank Employers versus Layan Commercial Bank Association. Number 3 is about court decision. The Industrial Court dismissed NUBE application to call the minister as a witness, ruling that he was not involved in the Memorandum of Agreement signed in April 2023. Lastly, about purpose of discussing this case. To understand the role of the MOA in defining right and obligation between union and employer. To evaluate the industrial relation process, including the role of conciliation and the industrial court in resolving labor dispute.
My name is Nuri Farishah Nabila binti Syahrudin. My number matric is 18 TPM 24 F1021 of the Memorandum of Agreement MOA. What is MOA? MOA is a formal writing agreement between the union and the employer. It defines the right, responsibility and benefit of all both parties. The MOA serves as a legal reference document that ensures both parties comply with the agreed terms. How the MOA defines rights obligation? First, it outlines key measures such as financial benefit, working hours, allowance, and employment terms. Second is ensure fair treatment for employer and clarity of obligation for employers. And third is in the event of a dispute, the MOA actually as the main reference for the industrial court to determine the outcome. Connection to this case is first is in the NUBE versus MCBA case, the MOA date 1st April 2023 was the central document in dispute. Second, the issue revolved around whether the festival aid state in the 2023 MOA should continue to apply in 2024. Third is the court ruled that only the valid and terms on the MOA were relevant to the case.
My name is Nurul Shamira, and now I will talk about the importance of the conciliation process. So, role of the Industrial Relations Department IRD. The IRD acts as a mediator between employers and union to settle disputes peacefully and fairly. Next, the main purpose of conciliation is to prevent cases from being brought to the industrial court. Also, it encourages both parties to negotiate, discuss and reach a mutual agreement without legal action, so that this process helps save time, reduce costs and maintain good relationship between employees and employers. Last but not least, in this case, for NUBE and MCBA, conciliation efforts were conducted in February and March 2024, but no agreement reached. Therefore, the dispute was referred into the Industrial Court on 16 April 2024 for further hearing. That's all from me. Thank you.
As you guys know, my name is Falihah binti Rosli, and today I will talk about should unions be allowed to summon minister as witness. In this case, the answer is no. There are three reasons why minister should not be allowed as witness in this case. For the first one is the minister was not directly involved in negotiation or signing of the Memorandum of Agreement aka MOA in 2023. Even though a minister holds an important government position, in this situation, he did not participate in any negotiation meetings. He also did not make any decision regarding the agreement. Plus, he did not sign the Memorandum of Agreement. Because of this, the minister has no first-hand information that could help the court understand what happened during the MOA process. For the second reason is the court ruled that NUP's action was an abuse of the legal process. The court find that NUP's attempt to summon the minister was inappropriate because, first, a witness should only be called if they have relevant or an important information about the case. Second, calling someone who has no direct involvement wastes the court time. It could also be seen as a form of political pressure and unnecessary influence instead of providing actual evidence. Therefore, the court viewed this action as a misuse of the legal system. And the last reason is the minister only took office after the MOA had already been signed. So this means he was not involved in any of the event leading up to the agreement, and plus all the negotiation and decision had already been complete before he entered the office. He also has no relevant details or background knowledge to contribute as a witness. So, calling someone who was not present during any part of the process will not help clarify anything in the case. Therefore, in this case, however, in other situation, if a minister is directly involved in the negotiation or policy decision related to the dispute, then it may be allowed with valid and relevant reason. But in this case, it's already stated that it was not appropriate for the union to summon the minister as a witness. That's all from me. So I will pass over the next slide to Jannah. Thank you.
Okay, now I will explain about new strategy justified. We have two views, which is positive view and negative view. For positive view, we have 3 points, which is new usually protect the member rights and fight for fair treatment for all the workers. Second, it show how the union was commitment and proactive in defending all the workers. And the last one we have involving the minister could add strong support to their case. Okay, from negative view, we have 3 points too, which is first, the court saw it as a finishing expedition. For example, looking for evidence without a good reason. Second, the minister wasn't involved in the original agreement, so his testimony was seen as irrelevant. And the last one we have, the move seemed political motivated, which made their legal case worker. Now let's move to listen learn, which is you have to understand the limit and rules of MOA, Memorandum of Agreements, defending the rights and obligation of both parties. For example, you have know the limit and rules of the agreement between workers and management. Next is use the conciliation process properly, because escalating dispute to the industrial cost, which is you have tried to solve problem of discussion before going to court. Next is the union should avoid abusing legal process such as calling irrelevant witness. For example, you don't call irrelevant witness, it can hurt your case. Next is the court only consider issue with the scope of grievances, no matter outside the MOA. For example, the court should only deal with issue directly relatable to the agreement. Okay, for the last one we have you should be professional, which is should dispute with fact, no with outside pressure or political. That's all for me.
I will talk about good recommendation. First, enhance internal negotiation between the union and employers to resolve issues before involving external parties. The group suggests that both the union and the employer should first try to solve problem internally through open communication, meetings, or internal negotiation, instead of immediately going to outside authorities or courts. It can save time and cost. Second, understand and follow legal procedures to ensure all actions are valid and relevant. Both parties, union and employer, should clearly understand the law, regulation, and procedures that govern labor relations and industrial disputes. It can ensure that every action taken is legal and justifiable. Next, make full use of mediation or conciliation processes before bringing the case to the industrial courts. Before filing a case in courts, both sides should use mediation or conciliation processes where a neutral third party help them reach an agreement. It can help maintain a positive working relationship even after the issue is resolved. And lastly, avoid action that may be seen as an abuse of legal process, such as calling irrelevant witnesses. Both sides should act in good faith and not misuse legal procedures to delay or manipulate outcomes. For example, bringing in witnesses who have nothing to do with the case. It can help maintain professional ethics and integrity. That's all from me.
In conclusion, the NUBE versus MCBA case highlight the importance of following the proper process and legal jurisdiction in industrial dispute. The court reject NUBE request to summon Human Resources Minister as he was not directly involved in the MOA, the center of the case. This case teaches that unions should focus on relevant evidence and resolve dispute professionally and based on fact.